I have looked into the history of Article 257, and if you look at the CKRC reports, Article 257 was intended to be exercised by the common man and civil society, and not anyone outside that category. I have therefore no hesitation in holding that the President cannot and should not initiate amendments to the Constitution under Article 257. Like to your JA, I'm certain that popular initiative is people-centric. The President cannot initiate the process by collecting 1 million signatures and crafting an amendment bill and then retire to await the same bill under Articles 257(9) and assent to it as President. That is an absurdity that could not have been the intention of the framers. Neither can he initiate a bill under Article 256(5)(a) and then under B, request the IEC conduct within 90 days a national referendum for approval of the bill and then retire to assent to it as a President. And therefore my finding is that he cannot initiate a popular amendment under Article 255.